Custody disputes can be difficult, often leading courts to appoint a special advocate to figure out what's best for the child caught in between. But tonight, two moms say there's a gap in accountability for a role with such high stakes. Senior investigator Rebecca Lindstrom explains.
There has been a lot of emotional and legal harm caused by this sort of broken custody process.
Two moms fighting for custody of their children. A fight, they say, impacted by the same Fulton County guardian ad litem.
They have a lot of power with little to no regulation.
We'll explain their concerns in a moment. First, you have to understand the role of a guardian. For that, we went to Diane Woods, who helped write the law that governs the job.
We are to be as objective as we possibly can.
This is messy. I really don't want to do 911 again, but you're about to force me to do that.
Woods says guardians are usually assigned when parents can't work together. It is their job to research the child's needs and then advise the judge on which parent is best suited to meet them.
Can you alter visitation schedules?
No.
Can you mandate that a parent record their conversations with their child?
I can't mandate anything.
Which brings us back to why Jordan Massey and Raven Evans are so upset. They feel some guardians treat their recommendations as mandates, and when questioned in court, judges don't give them enough scrutiny.
The guardian sends an email to all parties, and she states that I am no longer to have my court-ordered visitation.
Evans lives in Louisiana. The decision from her child's guardian came just one day before her son was to board a plane for his spring break visit. The guardian did act on the advice of the boy's therapist, and her recommendation was later approved by a judge, but without a hearing, despite Evans' request to have one. 7 months later, a new judge questioned what happened.
I'm concerned about the length of time she's gone without seeing the child, how the emergency order was done.
Massey says that same guardian overstepped her authority in other ways, like showing up unannounced late one night for the first home visit. This is body camera footage from Sandy Springs police after the guardian called 911 to complain Massey was being difficult. Massey says she just wanted to see some ID because she had never met the guardian in person.
She didn't even have on a lanyard or anything like that to identify herself.
Woods admits the system does lack accountability. There is no set process for how these evaluations should take place. While there is training required,
Recognition and assessment of a child's best interest.
there is no process to ensure that training is received.
Government doesn't want to have one more agency they probably have to fund.
Even so, she says guardians do the work because they want to make a difference.
If they go to trial, there's someone's to blame, and it'll be me or somebody in my role.
But what if one of those complaints is actually true? These moms say there is too much at stake to not have better accountability. In Atlanta, Rebecca Lindstrom, 11 Alive News, investigates.
I can see why some parents are concerned. Is this the first you've heard about this in terms of a parent reaching out in the form of a complaint?
No, we have parents who reach out to us every few weeks complaining about something that the guardian has done in their case, whether it be the actions that they're taking or even the amount that they are charging. But this is the first time that we receive complaints about the same guardian. Admittedly, it is usually the parent who is not getting what they want that is reaching out. And I have to say, we are in no position to say who should have custody of these children. And even if the guardians in these cases did everything right, researching the concerns, did expose a problem with accountability, and we really felt like that problem was worth discussing.
That guardian ad litem has such a critical role and really a lot of power if the judge just stamps off on a recommendation making it so. What kind of training is required for someone to have that position?
And that is exactly the concern, that, you know, if we're just stamping off on whatever they say without giving them that voice. Now, most guardians are actually attorneys. There are some smaller counties that allow someone from the community with a background in child welfare or the law to serve as a guardian. Either way, there is a set list of concepts that they are supposed to know, like courtroom procedures, how to perform a child custody investigation, how to detect abuse, child development needs, and interviewing techniques, things like that. But there is no set training program or even a checklist to see if the person has been trained. Now, Diane Woods, the GAL that helped write the law, says she would like to see oversight treated maybe more like mediators.
Mediators have to have mandatory training. We have to register every year. They do criminal checks on us, make sure we're not criminals mediating. And there's some requirements and prerequisites, a lot of training for being a mediator in the state of Georgia, like I think it's over 40 hours now, I don't even remember. But it's intense, and every year you've got CLEs. So with guardians, that's not the way it is.
Now, to help standardize some of that training, Woods did create Georgia Gals to hold events and a conference kind of to teach some of those best practices, discuss common topics that are coming up in the courtroom. And the problem is that they hold an annual educational conference, but it is voluntary and there's nothing that requires folks to register, which is why they don't even know how many guardians there are in the state of Georgia because there is no registration process.
All right. I'm curious if most of these guardian ad litems are attorneys. One might think, well, I could go to the Bar Association to file a complaint. Maybe there's some recourse in that avenue since they're an attorney. Is that the case?
And I thought that as well. So that is the first thing that I researched because I thought, well, maybe we could just defer these parents to the Bar Association and have that process follow out. But what I learned is that even though they are attorneys, the state bar holds no authority when they are working in this role as a guardian. Right now, the judge in your case really is the only person you can go to with your concerns. But in a case like Raven Evans, she had 3 different judges. She did request a hearing on the GAL's motion, and as you saw, the email exchanges that kind of went back and forth, the guardian just said, well, I don't really think that that's necessary. The judge's office sort of deferred to that opinion, and then they decided that the hearing would not be held. And so they thought that the next hearing was going to be a month later. So at that point in time, it might have made sense, yeah, let's just wait until the next month and then we'll take care of this. But court processes are constantly delayed. There's always something that comes up that's got to push it back. And in this case, that ended up meaning 7 months went by without her being able to see her son in person, and even her phone calls were impacted.
She reduced my communication to only twice a week, 15 minutes each call. And then she ordered that I pay for a communication app that would then record my calls with my son. And so that's where we are today. Not being able to see my son and not being able to talk to him.
2 hours a month of communication.
Yeah, and good with the math there. I think one of the other things that complicates this is that Raven was acting as her own attorney. And so when she's filing those complaints with the judge, it might look like from the clerk's office that this is just another mom complaining, but she's doing what an attorney in this case would be expected to do if your client had problems. So again, because of the way these court cases are set up, you've got a lot of room for just the guardian to make decisions that perhaps might be overstepping. Now, I will say, since I spoke with Raven, she has had a hearing. Her visitation has been restored. We're still waiting to hear, though, whether the judge is going to make her use that recording app during her phone calls, though. And again, Evans wants to know why she wasn't given the opportunity to push back before the order was signed by that judge.
We just have 30 seconds left. If accountability is the answer, how would you build that in?
I think that it kind of goes back to what we heard earlier, maybe with the mediator. Parents can request a new guardian be assigned if there is a major concern, of course, but they have to make the case that, things really need to change and that this isn't just a parent who is upset about what is going on. Again, they want those statewide training courses, they want oversight, and they want clear processes so that families who do feel like there's an issue have a way that they can know in advance to express that concern.
A really important conversation. So many families, children here caught in the middle. Thanks so much, Rebecca. If you have something that you would like Rebecca and our team to investigate, call us at 404-873-9111 or email us at investigates@11alive.com.